Squirrels of the world, we have an emergency filing. It's not an emergency, but making this video is an emergency. So this was only just filed this morning, July 8th, 2024, and it says here it looks like 9:02 a.m. And we're still exactly a week, as of today, we're exactly a week away, or a week out from when the mistrial was officially declared in the Commonwealth versus Karen Read. So it might feel like longer, but it was exactly a week ago today. The mistrial, of course, being declared on July 1st, today being July 8th. Also happening today is the hearing regarding Trooper Proctor. I believe that's happening literally right now as I record this video. So, and what my plan is here to do is I'm going to try to read this, and I'm going to do a live stream tonight, and we'll talk about the implications of this because of the very specific Massachusetts rules. We'll pull all that up. We'll pull up that specific statute that we had talked about before, but then I even joked about it. I joked about it, like when she declared the mistrial. Y'all can go back and listen to it. I was like, oh, how funny, we spent all that time and then it didn't even end up happening and it wasn't even necessary. Well, spoke too soon, because guess what? It was necessary and it didn't happen. The first thing I asked myself as I saw this was, why does it not just say motion to dismiss? Why is this an affidavit of Alan Jackson in support of defendant's motion to dismiss? And the first thing I thought of was, well, it's probably because he's licensed in California. So we're going to answer that question here in just a second. So I, Alan Jackson, declare I'm a partner at the Los Angeles law firm of Worksman Jackson and Quinn, LLP, and I've been licensed to practice law since 1994. I am counsel for Karen Read, appearing on her behalf in the Commonwealth of Massachusetts pro hac vice. So that's exactly what pro hac vice is when you're out of state. So pro hac vice is when a lawyer is admitted to a case and the court has granted them a limited license to practice in a jurisdiction where they otherwise would not be licensed to do so. Now here's the part that ends up involving Mr. Unetti. In almost all U.S. jurisdictions, lawyers who practice pro hac vice must do so in conjunction with a local lawyer acting as local counsel. And this makes sense because, as we know, laws vary state by state and then even within specific jurisdictions and in front of specific judges. There's all kinds of differences. Sometimes it can be a law or a rule. Other times it's just more of like a etiquette thing, if you will, common practice, that type of thing. You know, every different judge has their different way of doing things. So you'd want to come in and be able to know, obviously, the applicable and relevant major changes in terms of the difference of how the laws are going to vary by state. But you also want to get that down low, if you will. Or I think if I were to quote Trooper Paul, the lowdown, oh my God, of what exactly is the dealio, as it were. Local counsel therefore usually assumes at a minimum a role of monitoring the lawyer admitted pro hac vice. Local counsel typically acts as an anchor to the bar of a foreign jurisdiction. Here foreign just can mean from a different state, right? Exposing local counsel to liability for the acts or omissions of the lawyer admitted pro hac vice. Local counsel therefore usually assumes at a minimum a role of monitoring the lawyer admitted pro hac vice. So basically Mr. Unetti is liable there for any errors made by Mr. Jackson and is responsible for just sort of overseeing him and making sure he follows all the rules and guidelines, which of course he will and did and will continue to do. So what is the purpose of it? So basically it serves the purpose of providing a way for attorneys to practice law across state lines and ensuring that anyone that does this will have a local attorney that is qualified to advise them and their clients on the local laws, like I was saying, and to comply with local rules of practice and custom. So most courts and bar associations require that 1, local counsel vouch for the pro hac vice applicant regarding their ability to learn the local law and comply with matters of local practice, and 2, the pro hac vice applicant swears to abide by the written rules and make a proactive effort to learn them. Okay, so that's pro hac vice. So that is why this motion looks like this. It's an affidavit in support of the motion. So what we can expect, additionally, is a motion. So this does not substitute a motion. This is in support of a motion. So in other words, the motion will come from Mr. Unetti, and that might, I mean, we might see that today. I'll keep an eye out for it to be sure. But regardless, it makes sense that this would be first, right? And then that motion to dismiss will follow, and this is in support of that motion. Again, only just because Mr. Jackson is from California. And you might ask yourself, well, what's the deal with that? Why are they not licensed in all states? Well, it's not necessary. So being licensed in each state is not the easiest process, and it's actually expensive. Similarly to having like a medical license in each state. Like if you think about your expert witnesses and they're like, so what states are you licensed to practice medicine in? And they might name one or two, for example, because they don't need all of them, right? And it's expensive. It's a similar thing, right? So it wouldn't make sense for someone to be licensed in more than one state unless they are going to be regularly practicing in both of those states. So this Pro Hac Vice is a good way to, again, allow attorneys to practice across state lines in a temporary manner. Okay, so on Tuesday, July 2nd, 2024, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Based on my conversation with Juror A and that juror's description of who he or she is, where he or she was seated, and certain identifying information, in parentheses name/occupation, disclosed during the voir dire process, I was able to positively identify which juror he or she was. Juror A told me that he or she was seeing inaccurate reports about the, quote, split, end quote, among the jurors related to the mistrial that the court declared the day before. And this, I mean, I've heard every type of thing. I'm sure y'all have as well. And of course, none of it's been validated or verified. So yeah, the split is, we don't know. Maybe we're going to learn more in this document. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. And remember, what Judge Bev went and spoke to the jurors after she declared the mistrial, and she went and spoke with them privately. If she did poll them, then the purpose would be to then relay that information to the Commonwealth and the defense, and then they would have this information. So the fact that the basis of this affidavit has to do with what came from the juror, that leads me to believe that Judge Bev did not poll the jury. But I'm sure we're going to learn more. However, we can expect that one of the things she would have told them is that they don't have to speak to anybody, right, including the attorneys or reporters, journalists, what have you, but they can if they want to. And that, you know, that's up to them, basically. So here, that languaging is important because this juror wanted to tell them the true results. It sounds actually like they contacted the defense because of these inaccurate reports. So she wanted to be respectful, wanted to be respectful of the privacy of the deliberative process. As we know, they can't actually talk about the details, but did want to inform Mr. Jackson of the true results of that process. So Juror A indicated that he or she believes it is important to disclose such results because he or she believes that those results significantly impact Miss Reed's rights. Wow. Now, what's going to be interesting is to hear from one of our scroll friends who is there in the chat for a lot of the live recaps, Dr. Bob. Shout out to Dr. Bob, because he served as a jury foreperson in the state of Massachusetts twice. And he has a lot of insider information in terms of the rules specific to Massachusetts with these jury forms. And as we've already seen from the trial, they have their own system of doing things. There's some, again, these are the unique things that perfectly illustrate the Pro Hac Vice, why you would want local counsel, right? Okay, so coming up here where it says number 5, again, this is when it's going to get more complicated. We're going to talk more about this tonight on the live stream, but there's a lot specifically here, and hopefully Dr. Bob will be able to join us as well. And again, I'm going to pull up that statute where it talks about all of this. So Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Read is not guilty of count 1. Thank God. Thank God, right? We can all have a little bit more faith in humanity at this point, assuming this is accurate. At least we have that like officially here from somebody. Juror A was, and I didn't even read this full sentence, so they agreed that she's not guilty of count 1, which is the second-degree murder. Juror A was emphatic that count 1, second-degree murder, was, quote, off the table, unquote. Wow. And that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following that determination regarding count 1, the jury also unanimously agreed that Karen Read is not guilty of count 3. So in other words, the only count they were, and you know, y'all, we called this, The only one that they were deadlocked on was, guess what? The fucking confusing, this pisses me off. It was the second count, of course, right? We even speculated to that. It would seem reasonable that if they were going to go with a guilty verdict on count 2 in any of the ways, right, because there were the different options there, that they would also find her guilty of count 3. The fact that they had not guilty on count 3, this indicates to me, this is just my personal opinion, that they were just confused. They were probably confused about count 2. And this count 2, the one that was so fucking confusing, and we were all like thinking maybe that's what it is. They're hung up on count 2 because they're just fucking confused. Now, had this juror said they were also could not come to a verdict on count 3, I would think it would be different, right? Because then it's like, well, they just can't decide on those two. But the reason it seems more like now it was just confusion is because they had a not guilty on count 3. On July 1st, 2024, when the jury presented a note to the court, so July 1st, that's, they submitted several notes. So just to clarify, this is last Monday, so the day of the mistrial. So on July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Okay, that was on camera. It kind of seemed like they must have seen that note before she said that, and that they didn't have the court cameras on yet. Interesting that they didn't get to read the note before. Because we heard that. We heard her say that, and it seemed like, oh, wow, she must have already showed them the note. Incredible. Because every other time they already had seen the note. Once the jury was seated, the court then read the jury note verbatim in open court without providing any opportunity for defense counsel to be heard. The court declared a mistrial and excused the jury. She sure did, and it happened fast. Neither Miss Reed nor her counsel consented to the entry of the mistrial. Here it goes, guys. Here it goes. This is really incredible. What the Commonwealth could argue that, well, now in hindsight, now upon receiving this new information from this juror, now they're like saying, hold on, you didn't give us a chance to be heard about this. We didn't want a mistrial. And they could be like, well, you guys were really happy at the time that it was a mistrial, blah, blah, blah. This is crazy. This is insane. This is insane. Because I was surprised that they were happy with the mistrial. And I said that. I actually tried to console ourselves by saying, well, you know what, guys, it can't be the end of the world because they seem happy, right? That means something, yay. But in my heart, I'm like, I can't understand this, and this is depressing. So had they had the knowledge at the time of what the jury was going to say, and had any heads up knowledge instead of just Judge Bev just in open court, here we go, they could have actually said, they should have had time to think about how they want to handle it. She could have protected the record by letting them read the note, giving them that time, talking about it, whatever the case is, and putting it on the record that everyone was okay and now we're proceeding forward. And the fact that that wasn't done now leaves room for speculation as to what could have happened. And this is where the problem lies, in my opinion. They would have needed time to go and double check all the Massachusetts crazy random specific statutes that are applicable, right? And case law. All right, so, oh my God. So neither Miss Reed nor her counsel consented to the entry of the mistrial. And that's true. They didn't consent. And honestly, neither did the Commonwealth. Neither side was given a chance. So it just happened. I mean, you know what? Honestly, both parties here, I think, were sideswiped. Pun intended in that situation with Trooper Paul. Sideswiped by this happening. And what the defense is saying here that's problematic is also problematic for the Commonwealth. It's problematic for everybody that she did that, in my opinion. Right. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, that's count 2, and on which count or counts the jury may have arrived at a verdict. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and count 3. Yep. So that means that they only could retry her on count 2, the Commonwealth, if they chose to. They don't even have to, right? They could only retry on count 2. But again, this to me really is more indicative of the fact that they were confused by that verdict form. And I don't blame them. I don't blame them. That's fucked up. Miss Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States and the state of California, because that's where he is licensed to practice law, and the Commonwealth of Massachusetts, because again, he is able to practice there pro hac vice. Wow, okay. And at this point, the freaking hearing for Trooper Proctor might be done. I'm going to check on that. Y'all, I was going to do a recap tonight, but we're going to do an emergency live stream on this as well. Instead. But stay tuned. I do wonder if we're going to see them before the 22nd. I would say that the odds are pretty good for that happening after this. All right, y'all, thanks for watching. Hopefully see you guys tonight at the live stream where we can all talk about this, and also where we can review that statute that I've been referencing that we know Judge Bev did not follow. And also, again, I've not heard anyone else cover it. So hope to see you guys tonight. And thanks for being here, and thanks for being a squirrel.